video recording in the end. So good morning, good afternoon, and good evening to everyone who has joined us today. We are starting the webinar, Let's Talk About Sanctions, Views, Insights, and Updates from Diverse Perspectives. My name is Ivasechko, and I will be moderating this webinar for you today. And I hope we will have enjoyable journey together. For those who don't know me, I'm a board member of the International Law Committee of the Ukrainian Bar Association, and I'm also a counsel at Redcliffe Partners, focusing on international arbitration and litigation. First, I will briefly introduce the organizer of this webinar and the structure of this webinar. Then I will give floor to our fantastic speakers who agreed to join us today. So talking about the organizer of this webinar. The webinar is organized by the International Law Committee of the Ukrainian Bar Association. It is the biggest non-governmental, non-profit organization which unites lawyers from all areas of the legal profession in Ukraine. And even more, it includes many members from all over the globe. So just to give you some numbers, today the Ukrainian Bar Association is 7,000 members. It's 27 committees, 23 regional offices, more than 550 events per year, dozens of legislative proposals annually, and many, many other initiatives and projects. So if you haven't joined us yet, please do so, and let's explore and develop law together. So moving to the structure of today's webinar, technically, the webinar would be divided into three parts. So first, we will have 4 speakers, which would analyze sanctions from the perspectives of different legal regimes. Then we would have 2 speakers who would analyze sanctions' impact on international arbitration from the perspectives of international arbitration institution and a party to the recognition and enforcement proceedings. And the third part, the final but not least part, would be that we would address international economic sanctions for the reconstruction of Ukraine. So let's wait no longer and talk about sanctions. And I would be very excited to introduce our first speaker, who is Jan Dunin-Wasowicz. Jan is a counsel with Hughes, Hubbard, and Reed in Paris and associate fellow at the Royal United Services Institute. His practice focuses on transnational compliance, multi-jurisdictional investigations, and international dispute resolution. As part of his sanctions and trade controls practice, Jan has experience navigating economic sanctions, export controls, and trade compliance issues from both EU and US perspectives in a variety of contexts. Jan speaks and writes frequently on subjects related to EU sanctions, anti-corruption, and international law. He has been quoted in several leading media on EU sanctions topics. Jan is adjunct lecturer at Sciences Po Law School, where he has taught economic sanctions and anti-corruption. He has contributed to executive training programs on EU sanctions at the European University Institute. Jan has served as chair of the Anti-Corruption Law Interest Group of the American Society of International Law. He is also co-editor of the book, The Transnationalization of Anti-Corruption Law. Jan will start this webinar with an update on EU sanctions against Russia, which is a very important topic for us Ukrainians. Jan, thank you so much for joining us today. The floor is yours.
Well, thank you very much, and hello everyone. Welcome to the program. It's an absolute pleasure to be participating in today's discussion on such an important topic. I have been given the task to provide an update on EU sanctions against Russia, which is, as I hope I will be able to show, quite a difficult and daunting task. So I have sought to reduce that task a little bit to giving you a little bit of a recap of what has happened when it comes to the EU's response with sanctions, because that is only one element of the response since February of 2022. I will then try to highlight some of the main developments, dynamics that we have seen from a private practice, and here particularly from a compliance and investigations perspective. And then I will offer some thoughts on what may be ahead without speculating too much. So As I'm sure everyone knows here, the EU's sanctions against Russia didn't start in February 2022, since some measures had been in place since 2014. Nevertheless, what the sequence that started in February 2022 is quite remarkable, both from an institutional perspective and a substantive perspective. I certainly will not try to either overestimate the substantive part, but I also don't want to underestimate the achievement and the capacity that the EU has found to adopt the measures in such a coordinated and sequenced way. If we take a step back and situate ourselves in February of 2022, around the 23rd, the EU was ready to announce a first set or a first package of sanctions, which started what is often referred to as the scaled approach. So essentially, the European Union followed the path, a little bit like climbing the various steps of a ladder, and adding at each level, at each element of the ladder, additional measures. And there are multiple dimensions to these measures. I'll come back to that in a moment. But institutionally, it's important to keep in mind that the European Union is very much an organization of its own, and it's very much unique in the way it prepares, discusses, adopts, implements, and now enforces its sanctions. The first, I would say, governance or constitutional aspect of this is that the European Union is a union of 27 member states, and EU sanctions or restrictive measures, if we use the formal term in EU law, are adopted, and this is very important, following a principle of unanimity, meaning that all 27 member states must agree on the measures before they can become law. And this is done at the level, at the European Union level, in the Council of the European Union, where the various member states, all of the member states, are represented. So it's very important to keep in mind that this deliberative process in part explains some of the difficulties, but also highlights I think the significance of the achievement here when we come to what has been achieved so far from a decision-making process. So the measures are adopted at the EU level. That's the first thing that I think we should all keep in mind when we think about these measures. But they are implemented and enforced in a somewhat or fairly decentralized system, because it is incumbent upon each of the 27 member states to implement and enforce measures adopted at the EU level. And this is very unique to our regime, because and maybe we'll come back to that in the discussion. There may be nuances amongst the various member states on how to interpret, on how to apply, on how to implement certain of the provisions. Because it is nevertheless very important that there is a common view, that there be a common view on the core issues, the European Commission has played a significant role in issuing what we refer, or what the Commission refers to as frequently asked questions, in which the Commission provides guidance and answers on some of the questions that necessitate or require more guidance or more interpretation. There is only one interpreter of EU law, and that is the Court of Justice. And the Court of Justice has played and will likely play a greater role in the coming months in interpreting some of the provisions as it handles, as it is called upon to decide a growing number of cases that is brought before it. And so if we go back a little bit and think about the timeline, we had a first package of measure on the 23rd, followed by a second on the 25th of 2022. a third package that was spread between late February, early March of 2022, a compliance package on March 3rd, followed by a fourth on March 15th, a fifth on March 8th, a sixth package of measures on June 3rd, 2022, a maintenance and alignment package in July of 2022. And then we came to the fall in October with an eighth package of measure on the 5th, a ninth package of measures in December of 2022. And then moving into 2023, the European Union on the 25th adopted a 10th package of measures. And so without going into the now very voluminous set of restrictions, I would say that a few things about how these various packages have impacted the EU compliance environment. EU sanctions, as a general principle, didn't start in 2022. There were sanctions way before that. But I think now there is a recognition that the sanctions imposed against Russia and to some extent Belarus have really prompted a new era in sanctions compliance in Europe. And it's prompted a new era because, or at least it's initiated a new chapter, because the number of operators that are impacted by these measures has grown significantly. And so because of that, there's been a spike in questions, in concerns, in demands for guidance. And the topic has very much been at the focus of key management discussions in companies. Now, in this environment, having climbed progressively the ladder throughout the months of 2022 and into 2023, the question is, where are the trends? Where are the priorities? And so there is first a question of, can there be more sanctions? Can there be more restrictions imposed? Can there be additional individuals and entities added to the list of EU sanctions? That is a discussion that is very much driven by political considerations, and there are some ideas being proposed by various member states and the institutions. That's for one part. But increasingly, there is a very strong emphasis on enforcing the existing measures. And this has prompted very interesting discussions in various parts of the Union on how EU sanctions enforcement could be intensified and beefed up more generally. And here, there are a few avenues that are currently being pursued or explored. The first avenue is to harmonize, standardize the regimes in the various member states on the criminalization of sanctions violations. So a directive was introduced to that effect. It's now going through the legislative process. We understand that it's given priority, and there is political momentum and support to adopt the text as soon as possible, which would have, for among other consequences, the introduction of common definitions for the offense of violating the sanctions and common penalties. And so this would be an important reform at the member state level through the directive. There are other initiatives to beef up enforcement that are under consideration. One would be to expand or add powers to the future anti-money laundering authority, so that part of the sanctions could be enforced through it. And another angle is the discussion of potentially expanding the expanding the jurisdiction of the European Public Prosecutor's Office to give it jurisdiction over serious cases of sanctions evasion. And so all of these discussions are now ongoing. When it comes to the 11th package, and I will perhaps leave it there for now, and would be happy to come back to some of these questions if you're interested in the discussion afterwards. The focus, really, as it has been announced by the Commission, is on what we call fighting circumvention of EU sanctions. And I understand this is a topic that we will talk about a little bit later on in this webinar, so I don't want to say too much about it. But I will say that the recognition by the European Union and the various member states of the importance to fight circumvention is now taking the discussion on potentially imposing sanctions on third-party actors, whether they are third-party companies or entities participating in the circumvention or EU sanctions, or countries that insufficiently prevent the circumvention of EU sanctions. And so it will be very interesting in the coming weeks to see if the European Union decides to introduce either new types of designations. There is a legal basis now to do so, and there is an initial case in the 10th package of what we can call anti-circumvention designations. So will there be additional anti-circumvention designations? This is one thing we'll be on the lookout for. And more generally, will the EU introduce a new legal mechanism to incentivize and deter third-party actors from providing material support to Russia? So I think I will pause here in terms of the update, but I'm happy to come back to any of these questions later on in the discussion.
Jan, thank you so much for such an insightful update on EU sanctions against Russia. That was very interesting. I guess I will now introduce our second speaker, Sebastiano Nessi, who is an international arbitration and litigation partner at Curtis. He divides his time between Geneva, his hometown, Paris, and London. He has appeared as counsel in some of the largest commercial investment treaty and sports disputes of the last decade. He has a broad range of expertise with a particular focus on infrastructure and construction, energy, including nuclear, renewables, wind power, hydrogen and hydropower, oil and gas, banking, aerospace and transportation, telecommunication, maritime, commodities and pharmaceuticals. Sebastiano is the author of more than 50 books and articles. He has taught dispute resolution and arbitration at several academic institutions and law faculties in Europe and overseas. He is FCR fellow and he sits regularly as an arbitrator. He is recognized internationally in all major directories, including as global elite thought leader in arbitration by Who's Who Legal, and in 2021 he was awarded 2 prizes delivered by the International Financial Law Review. At this webinar, Sebastiano will deliver presentation on sanctions at the heart of arbitration disputes, the complex interplay between EU law and arbitration. Sebastiano, thank you so much for joining us today, and the floor is yours.
Many thanks, Victoria, for this very kind introduction, and let me thank you for organizing and moderating this very topical webinar, and let me also thank the International Law Committee of the Ukraine Bar Association for organizing this event. Let me start maybe by saying a few words by way of background to my presentation. I'm sure we all agree that the impact of sanctions on disputes, and more specifically in international arbitration, may take different forms. There are substantive issues, there are procedural issues, there are practical issues that may arise as a result of economic sanctions. As you said, what we'd like to touch upon today is more about substance over procedural practical issues, and more specifically, the impact of sanctions when these are at the heart of an arbitration dispute, and the interaction between sanctions on the one hand and the law of the European Union, which I will refer today as EU law. Broadly speaking, sanctions may affect the substance of a dispute in two different respects. I leave it aside the setting aside an enforcement part of it. In the first sense, let's say that there might be, jurisdictional issues. Typically, can a dispute involving the application and the interpretation of sanctions be submitted to arbitration instead of sales courts? And second, in what I call the merits or liability phase of the arbitration, which is how would sanctions impact the party's performance under a given contract, and what is the extent of a given party's liability? Now, let's delve maybe a bit into these points further, and notably with regard to the interaction between sanctions, EU law, and international arbitration. And I will start with the first point, the jurisdiction point. There are some discussions whether arbitrability is a jurisdictional issue or an admissibility issue, but I will not enter into the details of that. Let's call it a jurisdictional issue, and that is, of course, the arbitrability of a case involving sanctions. So arbitrability, as you all know, relates to the type of disputes that can actually be submitted to arbitration. Or if I put that in the interrogative form, can a dispute implicating the application and the interpretation of sanctions be submitted to arbitration? So sanctions regulations are generally, and I use the word generally because there are the views on this. So sanctions are generally treated as mandatory provisions of law because they impose basically binding obligation as a matter of public policy on those who fall within their scope. And on that basis, one could argue that because sanctions are in essence public policy regulations, disputes involving sanctions cannot and shall not be capable of resolution through arbitration, but only through state court proceeding as a matter of example. Now, of course, it is common ground that an arbitral tribunal is not able to enforce sanctions by way of imposing criminal sanctions, criminal penalties, criminal sanctions, administrative penalties on a party. But is an arbitral tribunal prevented from making rulings as to the consequences of sanctions on a contract? And is an arbitral tribunal entitled to interpret sanctions regulation if there is a disagreement between the parties as to the scope of the application of such sanctions? And that's really the issue of what I call the arbitrability issues. So to answer that question, maybe let's start with the basics. The jurisdiction of an arbitral tribunal is principally determined by the agreement of the parties, which is, as we all know, usually contained in the agreement to arbitrate. So that's very important. The wording of the arbitration agreement is therefore the first thing you would need to look at to see whether there would be any sort of restriction as to the type of disputes or elements into a dispute, such as sanctions, which can be decided or not through arbitration. The second point is a more interesting one. That's the law of the seat of the arbitration. You know that every arbitration has a seat, which is usually chosen by the parties most often in the dispute resolution clause of the contract. And that plays an important role as well on the issue of arbitrability. That's because the mandatory provisions of this law may, despite an agreement to arbitrate, prevent, in a way or another, an arbitral tribunal from exercising its jurisdiction. Now, I guess there is a general consensus that the application of sanctions to a dispute does not affect the arbitrability of such disputes. But here comes the interesting part. Remember what I told you about the law applicable at the seat of the arbitration. And here the practice is quite instructive, because on the one hand, you have several state courts. As an example, I just take the Swiss Supreme Court, which held that the application of sanctions as a matter of mandatory law to the merits of a dispute does not result in the inarbitrability or non-arbitrability of the dispute, and that the application of sanctions to a dispute does not therefore affect the jurisdiction of the arbitral tribunal. But other courts, and here you have two interesting decisions made by Italian courts, which have held, at least on these two occasions, that only disputes over rights of which the parties may freely dispose may be the subject of arbitration. And for these courts, and here I just try to simplify for the sake of and the benefit of my presentation, the reasoning is that the imposition of sanctions, depending on the kind of sanctions which are being imposed, affect the validity of the arbitration clause, because basically the parties lose their ability to dispose freely of their rights in relation to the subject matter of the dispute once the sanctions are imposed. So this is certainly a sort of exceptional approach to things. It's certainly not the most global approach, but that's something to keep in mind. And maybe let me also conclude this first point of my presentation, that flagging that the propositions I just made that cases involving sanctions are generally arbitrable knows also some exceptions or reservations, because there have been cases involving the applications of overriding mandatory provisions of EU law. And here comes the question whether sanctions are to be considered as overriding mandatory provisions of EU law. But when it comes to overriding provisions of EU law, it has been decided by a certain court in the European Union, German court, Austrian court, or outside of the European Union now, like English courts, that an arbitration agreement should be basically struck down, where the tentative purpose of that arbitration agreement was exactly to escape the application of such mandatory rules. And this was stated to hold true for arbitration agreements as well. So in the case I gave, sorry, it was state court proceedings, basically. So it was a forum, choice of forum clause. So my initial reaction, because I've heard that quite many times in webinars and conferences, those who consider changing arbitration seats and the applicable law to their contract with the view, or should I say sometimes with the hope to escape sanctions, would be well advised to seek legal advice before doing so, because depending on the circumstances of the case, this is not going to be an avenue which would remedy the issue of the application of the sanctions. Now, once we have established that the arbitral tribunal basically can proceed, that the dispute is arbitrable, what about the law applicable to the contract, and how should arbitral tribunal enforce that law? And does that encompass sanctions? So here I would like basically to tackle two issues. How would arbitral tribunal give effect to EU sanctions regulations if the governing law of the contract is one of an EU member state, French law, German law, Austrian law? And would that be different if economic sanctions are to be found in the law of a state other than that, the state of the governing law of the contract? And the tribunal has to decide whether or not to take that other law into consideration if that other law contains specific regulations in terms of sanctions. Now, it's been debated whether sanctions, generally speaking, should be characterized as overriding mandatory provisions of EU law, and whether they should be taken into consideration at all in arbitration proceedings. And here you will remember I just asked two questions. So I just introduced two hypotheticals. In the first hypothetical, the law applicable to the contract is one of an EU member state. And the general view is that the law found applicable to the contract by the arbitrators should include any sort of overriding mandatory provisions, including economic sanctions. So if you put French law in your contract, if you put Italian law in your contract, that should include also any sort of sanctions, because these are basically overriding mandatory provisions of EU law, which by essence are also part of the national law of the EU member states. But there's always a but, because otherwise it would be much less entertaining. Some scholars reject that sort of blanket application of the overriding mandatory provisions of the governing law of the contract. And basically they consider that the application of overriding mandatory provisions such as EU sanctions, having a public law origin, must be based on a specific connection with the dispute. And for these authors, this specific connection is required irrespective of whether the overriding mandatory provision is in the governing law of the contract, the law of the state where the arbitral tribunal is seated, or in the law of a third country. So I think it's fair to say that most of the time, the sanctions, EU sanctions, will be considered as applicable, but keep in mind that some authors think differently. Now, in the second hypothetical I just gave, the law applicable to the contract is not the law of a EU member state, but economic sanctions are imposed by the law of a third state. And now, does the tribunal have to take such sanctions into consideration? And if so, in what circumstances? Is an arbitral tribunal likely to give effect to the law of a third state? And the criteria to decide whether to apply an economic sanctions not belonging to the governing law of the contract is usually formulated, in different ways. And to be completely honest with you, I mean, the application of mandatory provisions of a third state in arbitration is probably one of the most debated issues in arbitration. So in some instances, and to determine whether to apply, if it's relevant, the law of a third state, which would maybe, impose sanctions, whereas the law applicable to the contract does not, depends on these criteria. So in some instances, arbitral tribunals have analyzed whether there is a close connection between the case and the state imposing an overriding mandatory norm. In some other cases, overriding mandatory provisions of a third state have been held to be given effect if there is a close, if the motive of the issuing state basically are relevant to the dispute, if the purpose of the legislation is relevant to the dispute, or if we're talking about typically, shared values between these different countries which are involved and parties which are involved into the dispute. So as you can see, when it comes to applying the law of the third state, you have to take into account different other consideration, and we could speak about that for hours, but we only have limited time available today, and there are other topics I would like to address quickly. Now, let's move on maybe to the next topic of my presentation, and I hope you're still with me. The next topic is somewhat related to the close connection test I've just discussed, which is what if, more specifically, the governing law of the contract is not one of the EU, but the seat of the arbitration is in the EU. So do you have to take into account the law of the seat of arbitration at all? So now I guess it's important to recall that overriding mandatory provisions of the state where the arbitration is seated are not applied automatically. Now, you have some authors who consider that, like courts, arbitral tribunals should apply these mandatory provisions of the law of the seat based on the sort of close connections test. You choose a seat, there's a law applicable, there's a close connection test. It is fulfilled, basically you have to apply that. Others have challenged that theory, considering that there's no, just because you choose a seat, it does not mean that you have to apply any sort of overriding mandatory provisions. It's not sufficient to establish the close connections test. So where does that leave us at the end of the day? And I think here it's really a matter of how do you approach things. If you consider that an arbitral tribunal can ignore economic sanctions of the state where the arbitral tribunal is seated, then disregarded economic sanctions could potentially lead to the annulment of the award. That's a possibility. But if the court competent is located outside of the EU, if the seat of the arbitration is outside of the EU, now there's no guarantee that disregarding EU rules would result in the annulment of the award at the seat of the arbitration. Now, my final point, what would be, if any, the role of the Court of Justice of the European Union in arbitrations involving the application of EU sanctions? And that's the Pandora box to a certain extent. Because, and I would be very, very interested to see how this how this evolves at the level of the Court of Justice of the European Union. Because it makes no doubt that within the European Union, that's the position of the European Commission. You all remember ACMEA, although it concerned, specifically investment treaty arbitration. It makes no doubt that both for the European Commission and the European Court of Justice, sanctions imposed by the EU are part of mandatory provisions of EU law. And for the European Commission and for the Court of Justice of the European Union, it is crucial to ensure that EU law is interpreted consistently throughout the EU, and that the questions of EU law which a tribunal may have to address can be submitted to the Court of Justice by means of a reference for a preliminary ruling. I think you all remember, that famous provision in the Treaty of the Functioning 267, I think, or 276, 67 probably, Treaty of Functioning of the European Union. But it's been also long acknowledged in the jurisprudence of the Court of Justice that arbitral tribunals do not benefit from this preliminary ruling procedure. And that is because an arbitral tribunal is not a court or tribunal of a member state within the meaning of the European treaties. Now, by contrast, a national court hearing a challenge to an arbitral award, or a national court being able to support the arbitral tribunal, as this is provided in many arbitration law of several countries, have the possibility to make a preliminary reference to the Court of Justice of the European Union. And now I think the question is, the inability of arbitral tribunals to refer questions to the Court of Justice is certainly perceived as problematic by the institutions, because they consider, and the Court of Justice of the European Union said that clearly, that arbitral awards are obliged to comply with EU law. And a failure to comply with EU law and overriding provisions bear, of course, the risk to see the award to be annulled. So when it comes to the arbitral tribunal, what is the solution when you are confronted with a situation where about a specific provision in the sanctions, where there is a disagreement between the parties as to the scope, interpretation of those sanctions? What do you do? And here a question would be, would you seize the courts at the seat of the arbitration, the state courts at the seat of the arbitration, to say, look, I have an issue as an arbitral tribunal. There's something I can't, basically, decide on. I acknowledge that it is EU law. Send that and make a preliminary question, or send a preliminary question to the extent that it's possible to the European Court of Justice. And here I will be slightly provocative. Is that warranted in arbitration? Would arbitral tribunal do that? We know their reluctance, to have state courts interfering in the arbitral process. And is that what the parties wanted initially also when they decided in the first place to enter an arbitral tribunal and not a state court, and certainly not the European Court of Justice in a commercial case to decide on an issue? Is that all legitimate and warranted? And you see, and this is probably this is my concluding remark. Arbitral tribunals play certainly a significant role in the application of EU law in the commercial context. And with the sanctions lies the entire tension between EU law its application, the specific nature of arbitration proceedings, which the parties wanted to fall, as I said, outside of the scope or influence of state's court, except in very specific circumstances when it's come, to challenging the award at the seat of the arbitration or enforcing the award at the end of the arbitration. And with that, I'm done, and I spoke too much as usual, and I apologize for that.
Sebastiano, there is never too much for an interesting topic, to be honest. So I wanted to say a huge thank you for such an insightful analysis of the complex interplay between arbitration and EU law and in sanctions regime. So now I would happily introduce our next speaker, which is Sebastiaan Bennink, who is the founding partner of BenninkAmar Advocaten. Sebastiaan's practice focuses on all aspects of international economic sanctions, economic laws, export control legislation, and related issues such as money laundering, terrorist financing, fraud, bribery and corruption, and other compliance-related topics. Sebastiaan regularly advises and represents clients in administrative and criminal proceedings and other regulatory enforcement matters, including internal investigations, settlement negotiations with and voluntary self-disclosures to national and foreign supervisory authorities. Furthermore, Sebastiaan lectures on economic sanctions and export controls and is a regular speaker at conferences and seminars about this and other compliance-related topics. In addition, Sebastiaan frequently publishes articles in legal magazines and is regularly quoted in various media outlets. Notably, in 2022, Sebastiaan was invited by the Dutch House of Representatives to address the Committee on Foreign Affairs on the application and enforcement of EU-Russia sanctions regime in the Netherlands. Furthermore, Sebastiaan is also invited by the Center for Strategic and International Studies to address members of the United States government and key players from the US semiconductor industry on EU and Dutch export controls and their respective trade law policies towards China. Sebastiaan is mentioned in Who's Who Legal as global leader in trade and customs, international sanctions, and in 2022, Sebastiaan was named the Lexology Client Choice Award winner in trade and customs international sanctions. Sebastiaan was appointed vice chair of the Export Control and Economic Sanctions Committee of the American Bar Association's International Law Section for 2023 and 2024. At this webinar, Sebastiaan will address EU-Russia sanctions regime with a focus on circumvention from the Netherlands perspective. Just give me a second, I will do the required organizational thing. Just a second. I guess I'm ready. Yes, here it is.
Great. Thank you, Victoria, for that introduction. And nice to have you all with us for such an interesting event, and also a great honor to be invited by the Ukrainian Bar Association. There's a topic that I want to discuss that Jan already touched upon, and that it relates to how should the EU respond towards Russia in the coming time. Should the EU impose additional restrictive measures, or should EU member states increase their supervision or enforcement efforts regarding the restrictions already imposed under the EU-Russia sanctions regime? And we can go to the next slide. The agenda that I have for this presentation is that I first wanted to touch upon how circumvention is laid down under the Russia sanctions regime. I will discuss a little bit about how enforcement looks like in the Netherlands, and then I will discuss a recent case that involves a Dutch microchip producer. And I wanted to touch upon a possible EU solution that is currently being discussed in Brussels in order to tackle the circumvention problem that is currently going on within the EU towards the Russia sanctions regime. We can go to the next slide. And if we discuss circumvention, then in this presentation it will relate to the evasion of sanctions by routing exports to Russia through third countries of high-tech goods and technology used in, amongst others, Russian weaponry and military equipment. There have been several cases that have now come to light, and various media outlets have published, in depth on these matters. And I do think this is definitely something that should get more attention, because it's something that to have sanctions is one thing, but to enforce them is another. And from a Western perspective, especially with the aligned countries that have aligned behind Ukraine in this matter, I do think that from the EU member states, it can be asked more as to how they enforce these sanctions and what capacity they divert to finding any circumvention of the Russia sanctions regime. From a Dutch perspective, we of course already had in 2017 the MH17 crash, where a civilian plane was shot down by Russian separatists in the eastern Ukraine. And as a result of that, the Dutch public prosecutor has indicated that enforcement of breaches of sanctions would become a focal point for the public prosecutor. The reality, however, as of then, is that we have had maybe 5-6 cases in the Netherlands of low-hanging fruit that barely made any difference in the cases that had been brought forward and the result that it had as to enforcement actions from a sanctions perspective. And we can go to the next slide. As in in every EU sanctions regime, there is a clause included that relates to circumvention, which goes along the line: it shall be prohibited to participate knowingly and intentionally in activities, the object or effect of which is to circumvent prohibitions in this regulation. So from that article, it shows that in principle, the activities that circumvention relates to are not itself laid down in the regulation itself. However, they do relate to prohibitions that are laid down in the regulation. And an example that I have now included is when you export a product via China and that product ends up in Russia in violation of the current Russia sanctions regime. And it's a quite simple example, but we have seen that there are extensive and very detailed schemes of parties that are involved in sanctions evasion, whether that is via China or whether that is via Turkey or other third countries. These parties that are involved in these schemes are trying their best, and they're it shows from practice that they're doing quite a good job at what they do. So there's a huge challenge for Dutch, but also EU and for authorities to come up with ideas to further strengthen on how to prevent the circumvention of sanctions. We can go to the next slide. I will touch upon how enforcement in the Netherlands looks like from a sanctions perspective. Of course, EU regulations have a direct effect, but in the Netherlands, we have the Sanctions Act that works as an act that implements these sanctions further into Dutch law. And for export controls, we have the Strategic Services Act and the Strategic Goods Decree. And enforcement of sanctions and export controls is then punished via the Economic Offences Act. And intentional, this is a criminal offense, and otherwise this is a misdemeanor. For companies, however, you will almost always end up in the criminal offense sphere, because the intent of a export is implied in your actions as a company. And the maximum penalty for a sanctions violation in the Netherlands is currently 900,000 euros, or if the judge in the court case considers that that is a too low of a penalty, he will impose a penalty of 10% of the yearly income of the company involved, which then can also be brought into the parent company of the possible subsidiary that is involved. Furthermore, there is a possibility for a 6 years imprisonment, which in various member states also differs. You also get a criminal record, which for companies can be a burden when they want to be involved in certain procurement. And the difference also between the member states and also Jan already also touched upon that, in the penalties and the imprisonment possibilities, also makes that you see that certain parties are starting to forum shop, which is, I think, a great issue as to enforcement within the EU, if we want to come to a common level playing field. We can go to the next slide. Yeah, here I want to discuss a little bit about the investigation and the investment sphere. Who is involved at first? This will be Dutch customs, who will highly likely stop an export before it leaves the Netherlands. And under general customs law, they are allowed to take samples or partially investigate. They are also allowed to enter or check and search buildings and premises, and demand that a means of transport will slow down, turn, land, or stop. We had a case of a yacht belonging to an oligarch who was contemplated to sail away from the Netherlands from the port of IJmuiden, was stopped by Dutch customs still in the territorial waters of the Netherlands. And that is an example of how then customs can intervene in a contemplated possible breach of sanctions. The investigative powers are then shared between the customs authorities together with Team POS, who has a further reaching investigative power. And then we can go to the next slide, because then there will be a transition in the sphere that we find ourselves in, from either the controlling phase by the customs authority into the investigation phase. And in principle, currently, if an irregularity is found during an investigation, the company or the individual involved will be a defendant in a criminal case, and a caution must be given. The file will then automatically be handed over to the public prosecutor. And currently, as a result also of the MH17 crash, the public prosecutor's office does not accept outside settlement anymore, and will, or at least that's the idea, bring a case forward for criminal prosecution. I do think that is the right way forward, but in some instances, I also, and that's from a US perspective in our practice that we see a lot, is that you're not incentivized by bringing certain issues forward to the authorities if you know that such a case will also directly be brought forward to the public prosecutor. So in some instances, I would, from personal and practical experience, I would also prefer to have that possibility to settle outside of court and go into the sphere of paying a fine or whatsoever, because there are a lot of examples in which this may enhance parties to come forward with possible breaches of sanctions or export controls for that matter, in which they may not have been knowingly involved, but which occurred due to certain situations that they found themselves in. And then such a possibility will leave an opening to enter into discussions with the authorities, point out what has happened, provide them with an overview of the facts, and also pinpoint the parties that should be then criminally prosecuted. And in practice, the transition from an administrative to a criminal enforcement is not clearly marked. So there is, like I said, a case file will be handed to the public prosecutor, and from off that moment, you'll find yourself in the criminal enforcement sphere. There's also from that moment no obligation to further cooperate, and on all rights that fall upon you as a criminal defendant will then apply. And go to the next sphere, the next page, please. And this is a case that a Dutch company found itself in recently. A Dutch producer of microchips, the Netherlands, from a semiconductor perspective, but also from a microchip perspective, have a very strong industry of producing this type of technology. And what we've seen due to the restrictions now imposed is that Russia has very much difficulties to buy and import certain high value technology which goes into their weaponry. And these chips are, for instance, used in Russian precision weapons, armored howitzers, cruise missiles, and attack helicopters. And the Dutch company had done its due diligence. They had investigated who they were dealing with, but the front that was put in place was so highly sophisticated that in the end their product ended up in Russia anyway. And when Ukrainian forces were able to shoot down any of these helicopters or investigate any of these missiles, it was found that these chips from this Dutch producer were found in Russia, or in these military weapons anyway. And this happened in the end, because then further investigation was conducted, and it was found out that Chinese companies were involved, but also an individual, a Russian individual, was involved, who then sent these chips via parcel post. And then again, the question comes for a lot of companies doing their due diligence, trying to the best of their knowledge to prevent these actions. To what extent are they required to investigate their business or not? And that is a question that we see that a lot of companies struggle with currently, is that compliance efforts, and you see that a lot of Dutch companies have pulled back out of Russia due to the war currently going on, and that not a lot of companies are still dealing with Russian parties, but still they then have to investigate and thoroughly investigate any third parties that they might be dealing with, whether or not those parties are considering to re-export and then circumvent the sanctions and re-export the products to Russia. And the due diligence requirements go very far in the Netherlands, and up to what is financially possible in your contemplated transaction. Take a certain percentage of that transaction and then invest that in your compliance efforts. And then a company can only afterwards show what it has done, and then it is up to the authorities to make an assessment whether that was deemed enough or not. We can go to the next slide. And this is currently being discussed EU solution, which solution we've also seen following the October 7 export controls imposed in the semiconductor industry towards China from a US perspective, is that the EU is currently considering to use its export control regime to restrict the export of certain controlled goods and technology to third countries that the EU suspects are involved in re-exporting such products and technology to Russia. So this legal mechanism would restrict the sale of specific goods and technology used in Russian military equipment to certain countries through the use of EU export controls. And this, of course, could have a huge geopolitical impact on certain EU member states dealing, for instance, with Turkey or Kazakhstan or any other third country that is neighboring to Russia, when such exports will no longer be allowed, purely because the EU suspects that that particular country might be involved in circumvention. And that is also something that I recently discussed with White House officials in the ASML case, is what could counter actions be from such third countries? And in this case, it was specifically China, which of course has a much greater power to counteract and impose its own restrictions towards member states such as the Netherlands in combating what they will find a non-founded solution to a problem that, for instance, China fully disagrees with. And from an EU, it will be interesting to see whether the EU is willing to go this far in order to increase its enforcement actions and to restrict the export of certain goods to third countries that in principle are not directly involved in the war, but that the EU suspects that they indirectly do have a large contribution to the effects of the war. So yeah, that is a solution that I'm also from my own practice currently very interested to see how that will develop. And that thereby I'm also coming to the end of my part of the presentation. We can go to the last slide, which I had the question for consideration. But seeing the timing, we might, of course, also go to the next speaker. And I would be happily and very willing to debate this question at another time in the near future with you. For this moment, thank you for having me, Victoria, and it was a pleasure to provide you with some insights from my end. You're on mute.
Apologize. Something always happens in such situations. I'm just trying to switch down the presentation. Just a second. Oh, okay, finally. Thank you so much for this fantastic and very insightful presentation relating to the sanctions from the Netherlands perspective. It was very interesting. I would now happily introduce the next speaker. And our next speaker is Alexandra Webster, who is a managing associate within the Disputes and Investigations Group at international law firm Simmons & Simmons, LLP. She has considerable expertise in financial crime compliance, including close to 10 years advising corporate clients from across multiple sectors, including financial institutions, asset management, and technology on UK and EU sanctions measures and related enforcement and litigation risk. At this webinar, Alexandra will make an overview of the UK sanctions regime to include a discussion of the legislative framework, key measures, and enforcement landscape, as well as insights on the implementation of the regime in practice. Alexandra, thank you so much for joining us today, and the floor is yours.
Thanks, Victoria, for that introduction. And thank you, everybody, for the chance to speak to you this afternoon and to discuss this very topical subject. So, as Victoria said, I'm going to start by giving you an overview of the legislative framework in the UK, which sort of underpins the sanctions regimes that we have in place. So you may know, since Brexit, since the UK left the European Union, we have had an autonomous financial and trade sanctions regime, which is implemented by a piece of legislation called the Sanctions and Anti-Money Laundering Act, which came in 2018, and various related regulations that sort of sit underneath that piece of legislation. And the UK also implements UN sanctions. I think it's fair to say that the UK sanctions regime remains broadly aligned with the EU sanctions regime, though there are some differences in the targeting, timing and scope of measures, which we'll touch on again a bit later in the discussion. The UK has in place both country-specific and non-country specific sanctions regimes. We have country-specific regimes in place in respect of 26 countries. I won't list them all, but some examples include Syria, Libya, Iran, Russia, of course, and Belarus. And these country-specific regimes most commonly restrict certain activities or dealings with designated persons or companies, rather than imposing comprehensive or complete bans on any kind of interaction with a jurisdiction. We also have in place in the UK non-country specific regimes, which impose restrictions, principally asset freezes, for conduct or activity that's not linked to a particular jurisdiction. So some examples of the non-country specific regimes that we have in place include a global human rights sanctions regime, which was introduced in 2020, a regime to prevent and combat serious corruption, which was introduced in 2021, and certain measures to prevent cyber activity, which risks undermining the integrity, prosperity, or security of the UK. I think consistent with EU measures, sanctions can be imposed for a number of different reasons, including compliance with UN obligations, preventing terrorism in the UK or elsewhere, promoting national or international peace and security, for foreign policy objectives, resolving armed conflicts and protecting civilians, addressing human rights issues, imposing controls around weapons, and promoting democracy, the rule of law, and good governance. UK sanctions regimes apply broadly, so they apply to all persons who are within the territory of the UK and to all UK persons, so nationals and entities, wherever they are in the world. There are very limited exceptions to the UK sanctions regimes, but certain activities which would otherwise breach a regime can be permitted where specific licenses are sought from the relevant regulatory authorities, but only where certain grounds which are provided for in the legislation are met. These grounds include allowing a designated person to meet their basic needs, payment of legal fees, satisfying a prior legal judgment or a decision that's been handed down before a sanctions regime has come into force, dealing with an extraordinary situation, which is defined as a one-off or an unexpected circumstance, using designated persons' funds to satisfy prior obligations which they owe to third parties, providing humanitarian assistance, medical goods, distributing food, that sort of thing. There are also general licenses which are issued by the authorities which permit specified activities to be undertaken by a broader class of persons, and these usually apply for a limited period of time and where there's a particular policy justification to allow that activity. General licenses are issued at the discretion of the authorities and can't be applied for by specific parties. So that's sort of what I wanted to cover in terms of the legislative framework. Moving on now to consider some of the key measures that we see imposed as part of sanctions regimes in the UK. I think consistent with the EU and the US, the most common financial sanctions restriction that we see is the asset freeze, which prohibits dealing in funds, which means any kind of financial asset or economic resources, which are any asset that may be used to obtain goods or services, which are owned, held or controlled by certain named individuals or entities, which are known as designated persons. It's also prohibited to make funds or economic resources available to those persons or to third parties who are acting on their behalf. The most common trade sanctions controls that we see restrict the import, export, transfer, of certain restricted goods and technologies and the provision of services related to them. And often these restricted goods and technologies are linked to military uses. Under the UK financial and trade sanctions regime, circumvention and evasion, which we've also discussed today, are prohibited as well. Now, I think consistent with some of the comments that Jan was making, it's important to recognise that with the introduction of the Russian sanctions regime in 2014 and its significant development over the last year, we have started to see financial and trade sanctions measures which are much more targeted than the sort of traditional restrictions that we saw in the past, and which introduced new concepts as well. As Jan alluded to, the Russian sanctions that have been issued over the last year have been unprecedented in their pace and complexity, in the volume and nature of the measures that have been introduced, in the cross-sector impact that they have had, the fact that they're targeting a significant economic power, which had high levels of integration within the international financial system, and also the global trade and commercial investment landscape. So the UK authorities, together with others, have imposed a range of different prohibitions and restrictions under the Russian sanctions regime, which target Russian financial institutions, defence and energy companies, oligarchs, government officials and their owned and controlled entities, certain state institutions as well. New measures have also been imposed to restrict new investment, lending and certain types of commercial activity involving Russian persons or companies or on Russian territory. Restrictions apply to prevent the provision of certain professional services, including accounting services. There are export bans in place now that extend beyond military and dual-use goods to include certain commercial and luxury items as well. And import bans have been introduced in relation to Russian origin goods, which generate revenues for Russia. And there are also a range of other restrictions in place which target entities and activities which are linked to sectors of strategic or economic importance to Russia, including most obviously the oil and gas sector. There are similar, although much less extensive, measures that have been imposed in relation to Belarus as well. Consistent with what Jan's been saying as well, the measures continue to be added under the UK sanctions regime. Most recently, last month, there was an expansion in the trade sanctions that apply, and certain persons were designated who are believed to have facilitated or enabled sanctions evasion activities. And it's expected that further measures will continue to be implemented over the coming years, probably. Together with these new measures, the general licensing regime, which I mentioned, has also been significantly expanded. And there have been, I think, 55 licenses which have been issued at various points in time since February last year, which have allowed for various types of activities. But examples include permitting wind down periods for concluding commercial activities which involve designated persons, allowing for payments for legal services, humanitarian activity, allowing persons, individuals to continue low value retail banking activity involving designated Russian banks. Those are all examples, but I think the main point to take is that these general licenses tend to be issued with the intention of sort of lessening or reducing the negative impact which innocent third parties may feel as a result of the sanctions measures, and to allow for certain essential services to continue. Alongside these expansion in the measures that apply, several reforms have also been introduced in the UK in order to support the implementation of the Russian sanctions regime. And this includes several changes which were introduced last year as part of a piece of legislation called the Economic Crime and Corporate Transparency Act. And one of the main changes that this legislation introduced was a reduction in the threshold required for the Office of Financial Sanctions Implementations, that's the Enforcement Office, to bring enforcement actions against those who have breached sanctions. So it reduced the sort of evidential threshold required down to a strict liability threshold. And what this means is essentially a sanctions breach can be committed regardless of whether the person acting in breach intended to breach sanctions or knew that they were acting in breach. So that's quite a significant change. Also under this legislation, a quicker process was introduced for implementing new designations, which essentially allows an emergency fast track procedure to be followed where there are persons who have already been designated by the EU and US authorities, but the UK hasn't yet designated them. So that's sort of a bit of an overview of the types of measures that we have in place in the UK. Moving on now to look a little bit more closely at the enforcement landscape. Now, there are various different agencies in the UK that are responsible for administering and enforcing the UK sanctions regime. This includes the Foreign, Commonwealth and Development Office, which is in charge of sanctions policy and deciding who will be designated. Then you've got OFSI, which I've mentioned already, which implements financial sanctions and enforces civil breaches. You've got the National Crime Agency, which enforces criminal breaches of financial sanctions. And then you've got the Export Control Joint Unit, which implements trade sanctions, and HM Revenue and Customs, which enforces trade sanctions. So there are a range of different bodies that are operating in that space. Despite that, historically, there have been low levels of enforcement for sanctions breaches in the UK. And by way of example, since 2019, OFSI has issued only 8 penalty notices. One of those notices imposed a penalty of 20 million, but the remainder were significantly less, and the breaches that have been targeted were relatively minor. So OFSI is markedly less active than its comparator agency in the US, OFAC, and it has been subject to significant criticism as a result of this. Now, it's expected that enforcement of sanctions breaches in the UK will increase this year, with the expansion in OFSI's powers to impose civil penalties that I mentioned, and also in light of increased coordination between the UK, EU and US authorities in the enforcement space, particularly in relation to circumvention and evasion offences, which, as we've discussed, are believed to be undermining the impact of the Russian sanctions regime. So as a result of that, we're expecting to see a rise in global investigations involving multiple different jurisdictions. And there are also various steps being taken within the UK to support increased domestic enforcement. In March of this year, the UK government announced a £50 million economic deterrence initiative to strengthen implementation and enforcement, including by tackling sanctions evasion. In its economic crime plan for the period 2023 to 2026, there's a pledge to expand the capacity of the National Crime Agency to target assets that are hidden in the UK by corrupt elites and to focus on criminal sanctions breaches. There are also various steps being taken to improve the coordination between the different authorities operating in the UK and to identify and disrupt enablers of sanctions evasion. The UK's economic crime plan for 2023 to 2026 also includes a commitment for the UK to consider all possible options for seizing and confiscating assets in the UK that have been frozen that could be used to rebuild Ukraine. And this is a proposal that has been debated before the UK Parliament, but it's quite widely recognised that it's a legally challenging proposal to implement, and that formulating appropriate legislation to support this proposal is likely to take some time. And the principal reason for that is that there's a relatively low evidential bar, which needs to be passed in order to apply a sanctions designation, and that designations are usually based on sensitive and non-public intelligence information. This process or this standard that has to be applied is not consistent with existing asset confiscation provisions under UK law, which require detailed prior investigations in order to establish that an asset is the proceeds of a criminal offence, a particular criminal offence, and that tends to require significant resourcing commitment from the authorities in order to put those investigations together. But it's not a proposal that's gone away, and it will be debated again before the Parliament in November, and there are definitely people thinking about the best ways to try to take that forward. In the meantime, there's an interim step that's currently under consideration as part of the Economic Crime and Corporate Transparency Bill, which is making its way through the parliamentary process at the moment, which would impose a duty on designated persons to disclose assets which are under restrictive measures, and potentially disclose assets which they owned in the 6 months prior to being designated as well, with any failure to disclose those assets a criminal evasion offence. And it's hoped that this interim step would increase transparency and assist the authorities in meeting the legal and evidential burdens which they would have to meet in order to confiscate those assets. It would also have the benefit of strengthening the existing sanctions regime by combating evasion and identifying additional assets for freezing. Now, this proposal has cross-party support, but the legislation in which it has been proposed is still making its way through the legislative process. So it's something to keep an eye on that we might see coming in this year, which would be a very positive development. So that's it for the enforcement landscape. And finally, I'll just share a few thoughts on the implementation of the Russian sanctions in practice, particularly by businesses, which tends to be where I get involved, or where my clients come to seek some support. So I think it's fair to say, and I expect it's known to everybody on this call, that businesses across all sectors have struggled to navigate multiple wide-ranging and sometimes conflicting regimes, which in certain circumstances have extraterritorial reach, and have been confronted often with the need to make rapid strategic decisions based on changing information and with the benefit of limited regulatory guidance. What this has meant is that the Russian sanctions measures have had a significant operational impact for many businesses and have created a challenging and costly compliance environment. This is a burden that's been shared by the regulatory authorities also, who have faced and continue to face significant demand for licenses and engagement and guidance from industry amid pressure on resourcing and staffing. However, as a result of this sort of challenging experience over the last year, I think it's fair to say that UK businesses are now better placed than ever to respond quickly and effectively to complex new sanctions measures. This is due to an increased investment in specialist expertise, robust compliance architecture and staff training, so that staff are able to identify exposures to sanctions risk, and the availability of somewhat clearer and more comprehensive guidance from the authorities, although there's certainly still room for improvement on that front in the UK. However, despite this, there are practical challenges that remain for businesses in navigating and implementing expanded sanctions measures, which the UK government will be under pressure to mitigate this year. And there are various, but a couple that I'd like to highlight. And I expect this will be consistent experience of everybody on this panel. But despite sort of unprecedented levels of coordination at a policy level, there are still quite significant divergences in the scope and timing of measures which are introduced by the UK, EU and the US authorities. And what this means for global businesses in particular is that there is a risk that by complying with one regime, they may place themselves in conflict with another. And it also makes globally consistent sanctions policies very difficult and sometimes impossible to implement across an entire business. And I know that there's certainly focus between the UK, EU and the US at trying to reduce this divergence as much as possible this year. It's also worth noting that OFSI, the principal enforcement authority in the UK, continues to face significant resourcing pressure. They have recently expanded their staff numbers to 100, but they have a significant backlog of license applications and there are significant delays in processing these. And this can cause financial losses and significant operational disruptions for businesses. And there's certainly pressure and expectation that OFSI will improve their sort of response timelines and help to ease that impact on business this year. So that was it from me. Hopefully that was useful to you all. And again, thank you for giving me the opportunity to share those insights.
Yeah, Alexandra, thank you so much for such an interesting and comprehensive overview of UK sanctions. That was very insightful. I would now announce that we have completed our first part of this webinar, which is the largest part actually of this webinar. It relates to sanctions from the perspectives of different legal regimes. And now we would be switching to the second part of the discussion, which is the sanctions impact on international arbitration from the perspectives of international arbitration institution and a party to recognition and enforcement proceedings. And now I'm very excited to announce our next speaker. It's Niamh Leinwather, which is the Secretary General of the Vienna International Arbitral Center. Niamh has taken office as the Secretary General of the Vienna International Arbitral Center since 1st January 2022. Of Irish origin, Niamh has both common and civil law background. She has the degrees in law from the University College Dublin and the University of Vienna. She was the first Irish woman to be admitted to the Austrian bar in 2013 and has over a decade of experience in international dispute resolution and fresh fields in Vienna, where she acted both as counsel and arbitrator. Notably, when the war in Ukraine started, Niamh was the first representative of an arbitral institution to publicly discuss the interplay between sanctions and international arbitration that essentially broke the silence on the matter, and this matter was extremely important for the users of arbitration services. At this webinar, Niamh will address international economic sanctions from the perspective of an arbitral institution and uncover some interesting insights for our audience. Niamh, thank you so much for joining us today and for your time. The floor is yours.
Thank you, Victoria, and thank you for the kind introduction, especially for the mention about the sanctions initiative, that we were, in fact, one of the first institutions to flag the discrepancies in the sanctions regime last year that did, in fact, hinder us from administering arbitration proceedings, but I'll get to that in a moment. So I just wanted to briefly take quite a practical approach to the topic today, and I will be quite brief in the interest that we're running out of time, and it's Friday afternoon where I am, and people probably are thinking about the weekend already. So there are two aspects that I wanted to cover. One is something that we get asked on a regular basis, what our sanctions policy is at the institution and how it works in practice. And second, a few thoughts on the specific regulations, the one that Victoria mentioned, and a second one that still is unfortunately quite ambiguous, and I have some quite new, hot off the press information on that. So as regards the sanctions checks at VIAC and how the process works, I think the most important thing to say at the outset is that VIAC is dedicated to treat parties of all nationalities equally. So the impartiality and independence of a VIAC proceeding remains the same for all parties. So in that respect, the sanctions regime has not changed anything. However, of course, the regulations have resulted in VIAC adding a number of administrative steps in our case management process. So we do undertake a number of sanctions checks at various stages of the proceeding. And of course, when we do these checks, we are extremely vigilant of our confidentiality obligations towards our users. So what sanctions do we look at? We look at the regimes in the United Nations regimes, the European Union regimes, and the US mainly secondary sanctions. And in conducting those sanctions checks, we have sanction experts within our team. And obviously we use public sources, but we also have an internal state-of-the-art research database to establish any sanctions with the various screening on, screening off functions, fuzzy names, and all of these particularities that keep my case managers busy on a daily basis. So when do we carry out the sanctions checks? There are essentially, in short, whenever a payment is made in a proceeding. So initially, when we get a case in, the registration fee will be paid, and the filing of the statement of claim and the answer to the statement of claim will require us to conduct a sanctions check. The payment of any advance on costs or any additional advance on costs, and obviously at the end of the proceedings when payments are made to arbitrators, or any leftover advance on cost is returned to the parties. But also, of course, at any time during the proceedings, if we are requested by banks or authorities to do so. We have obviously, from a practical perspective, had to change some of our communications with our parties. So in the first letter that we sent to the parties, we advised them that we carry out these checks, that they have to provide us with the relevant information, and also encourage them to inform us of any sanctions that may be relevant that may come up during the proceedings. So what we need from the parties is the identity of the parties, the identity of related entities. We also look at the ultimate beneficial ownership of the parties or related entities, and essentially the control structure of the parties. So that's kind of, in a nutshell, how the sanctions check process works. As regards payments to arbitrators or and lawyers, that's a question that we obviously got inundated with last year. If the good news for parties is, I guess, that there is an exception in Article 4, Paragraph 1b of Regulation 262/2014, which foresees that if there are frozen funds or economic resources, that these can be released if they are intended to exclusively pay reasonable professional fees or reimburse incurred expenses associated with the provision of legal services. So if it was a case that we would have to use this provision, we have to request that the Austrian national authorities, which in our case is the Austrian National Bank, release these funds. To be honest, this is a situation that hasn't occurred so often. If it does, arbitrators have to be particularly patient with us, because there will be a delay essentially in putting it through the bureaucratic system to get those funds released. But legally there is a basis there for the arbitrators to get their payment. Now, the second part of what I wanted to discuss today is what you alluded to at the beginning, Victoria, and I'm sure many people on this call are aware of the fact that I think it was the EU's fourth sanction package that was issued on the 15th of March last year, which foresaw an absolute transaction prohibition with the listed entities in the respective annex. This was, obviously understandable, that the idea behind it, or the thinking behind it, was an absolute prohibition of all business transactions, but there was no definition of the term transaction. Maybe just to give you an insight, my sanctions expert, who is normally at the time anyway, a very particularly pragmatic individual, said to me, I think this one is a real problem. And I think Victoria and you and I talked about this beforehand. I raised this at the Paris Arbitration Week last year, and I remember somebody in the audience stood up and said, well, if you ask the European Commission too many questions, you're not going to get your desired answer. But this, we had a number of arbitration proceedings that were directly affected by this provision. And it kind of put us into the dilemma that we had to stay those respective proceedings. There was obviously an issue that was discussed in detail with the board, and the conclusion, we came essentially to the conclusion that we had no choice as an institution but to stay the proceedings. We had many, to be honest, unhappy arbitrators who, obviously called into question the thinking behind, or argued that the logic behind this provision surely could not be to hinder justice for certain parties. And in our case, we didn't have any situation like this, but I know many other European institutions did actually have situations where arbitrators resigned as a result, because they were concerned, on the one hand, that they might be violating sanctions regulations, and I think maybe just the unclarity of it made them essentially feel more comfortable to resign from their position. So that's obviously an issue as an institution that is extremely concerning. And we initially here at VIAC, we brought the problem to the Austrian Ministry and to the Austrian National Bank, who essentially referred us to the Commission. And then we got together with the other arbitral institutions in Europe, so the SCC, the FAI, the CAM, a DIS, and the Swiss Arbitration Centre. And the initial response that we got was not particularly pleasing. However, to cut a long story short, within 4 months, so on the 21st of July, the Commission adopted an exception specifically for arbitration for arbitration proceedings, which meant that we were happily able to continue administering the arbitration and proceedings that had been stayed at the time. So the next regulation that I just wanted to flag is related to the post-award phase, which in fact is not really something technically as an arbitral institution that is something that we are necessarily involved in. So if we look at our rules or across the board, arbitral rules of arbitral institutions really only provide for an involvement of the institution post-award if there's a supplementation, a clarification or a correction of the award, or if there's a necessity for the award to be the final and binding nature of the award to be confirmed by the institution. Generally though, in the post-award phase, we do try and support the parties if they're trying to serve their award on their opponent, or if they're looking for a trusted lawyer in the enforcement country. And it was brought to our attention that Article 5.1 of Regulation 269 is essentially problematic for arbitral proceedings. I'm sure everyone on the panel is aware of this one. For those of you who are not, so Article 2 of the said regulation provides that all funds of the persons and entities shall be frozen, and there is a derogation in Article 5.1 that authorises local regulators to release frozen funds or economic resources for the purpose of complying with or enforcing a judicial, administrative, or arbitral decision. However, in contrast to judicial and administrative decisions, the regulation limits the scope to arbitral awards rendered prior to the date on which the natural or legal person or entity was added to the sanctions list. So in short, if frozen assets can only be released if an award is issued before the assets were frozen. We had an intense discussion with the same group of arbitral institutions as to whether it is appropriate for institutions to get involved in this phase of the proceeding. Like I said, we came to the conclusion that, in fact, in the interest of arbitral proceedings as a whole, it is part of our obligation to request clarification on this. So we sent a letter to the Commission again in January of this year, highlighting that maybe the ultimate goal of the regulation could not have been to differentiate between arbitral awards and judicial decisions, particularly given when this regulation was enacted initially, there were only 12 persons on the list. And now there are, so 12 sanctioned individuals, and now there are 209 individuals and 1,499 entities. So, you know, it's a phenomenal amount of parties or entities and individuals that are now affected by the by this regulation. Unfortunately, we did get a response from the Commission. This is, as I said, a very new development. So on the 2nd of May, the Commission has responded to us saying that the wording of the regulation is a standard wording that is used also in the Council regulation on cyber attacks and the Council regulation in relation to Myanmar and Burma. And this was a deliberate choice of the legislature that the arbitral awards rendered after the date of listing of the party in question are not subject to the derogation. Needless to say, this is extremely frustrating, but it is, you know, like I said, and that's why I emphasized it in before, when we launched the other sanctions initiative last year, we got a similar frustrating response. I think maybe there is just a lack of understanding as to the effect or the ultimate effect that these regulations have if they are not they're not taking into account the niche that is arbitration, or maybe there's a lack of awareness of the potential repercussions that these provisions can have. So yeah, watch this space is what I would say on that one, and we hope that we can you know, make some kind of a movement there in that regard, or at least we're working on it. So I'd leave it at that, Victoria.
Thank you so much for these insights into the interplay between arbitration and sanctions from the perspective of an arbitral institution. It was very valuable. And now I would pass the floor to our next speaker, who would also address the interplay between sanctions and arbitration, but from the perspective of a party to enforcement proceedings. And I'm excited to introduce Dr. Manuela Grosso, who is a managing associate, lead attorney at law at the dispute resolution practice group of KPMG Legal Warsaw, a law firm in Budapest. She has a PhD in law from the ELTE Law School in Budapest and has also obtained an LL.M degree in the US and global business law for the International Business Lawyers from Suffolk University in Boston. She's a visiting lecturer at ELTE Law School, where she teaches private international law. She has gained significant experience in domestic and international arbitration and commercial litigation involving complex cross-border issues. She represented clients under the ICC, Untitled and Hungarian arbitration rules. She was a visiting researcher at Cardozo School of Law in New York and cooking program for conflict resolution. She is a trained mediator and is also involved in mediation training-related activities. And furthermore, she is a Vienna International Arbitral Center Community Ambassador for Hungary. At this webinar, Manuela will address international commercial arbitration involving economic sanctions, some aspects on recognition and enforcement of arbitral awards. Manuela, the floor is yours.
Thank you very much, Victoria. It's my honor to be there. Thank you for the kind invitation. As I mentioned, I have a PowerPoint presentation. If you don't mind, I will share now my screen. Just a moment. If you see it, please let me know. Yes, thank you. I see. Just I will talk briefly and touch upon certain issues of recognition and enforcement of arbitral awards. Actually, today we already mentioned some aspects: arbitrability, law applicable, and of course the institutional perspective and the importance of the seat of arbitration in the case when sanctions are concerned. But we can see, of course, that it was already mentioned by Niamh, that the impact of sanctions, and from a party perspective, of course, it's important, and on a certain level, even from the perspective of arbitral tribunal, to ensure that to make an enforceable award. So the impact of sanctions continues even after the arbitration is terminated, so that we can almost say that this is kind of the post-award implication of the sanctions, with a focus on enforcement and recognition. First, I will talk briefly about foreign policy too, but by how we come around with public policy issues, and of course, focusing the New York Convention, since I would talk about international commercial arbitration, and we would take care of enforcement of arbitral awards, not on domestic but international level. Then I will talk a little bit about making payments. Many of these issues were already mentioned actually by Niamh. I was happy to hear about challenges with the case of asset freeze and the very contrast view, and very contrast, actually not only view now we see situation if we compare court and administrative decisions to arbitral awards. And if we will have some time, I will talk a little bit about enforcement of international arbitral awards in Russia in the sense of exclusive jurisdiction and some plans to even make the exclusive jurisdiction provisions of the code of civil commercial code of Russia in this sense even broader, even though we already have some provisions on exclusive jurisdiction there. Before talking about the New York Convention, we all know, of course, the New York Convention as the fundamental instrument in this context of international commercial arbitration, and we take it as granted because it's almost generally agreed by that time that economic sanctions are part of public policy. Let's say they have a public policy character. Maybe it's more precise to put like that. Although we can, of course, argue against these, since sanctions have rather temporary restrictive measure, and sanctions may be lifted by public policy. Of course, usually the general value of a system, a social system, fundamental basic legal principles are included. Saying all that, sanctions, and especially by that time, we can see an almost unprecedented wave of sanctions and consensus in terms of imposing sanctions. We can see the fundamental policy objective and value, actually, that sanctions become like that from our context of talking about enforcement and recognition. And they are indeed a new aspect of public policy. So saying that, that's why I take it as almost as not as a rule, but as a starting point that now we are talking about a public policy issue indeed when we are talking about economic sanctions. The New York Convention, we need to look at it, and which provision can help us, or on a long term, we rather would have problems with it. The first one, of course, is rather about arbitrability. I would not really reflect on that the subject matter of a difference is not capable of settlement by the arbitration under the law of that country, I mean the forum, the place of the enforcement. Which is more, don't want to say that it's more important, but definitely more highly discussed is the second one, the recognition and or enforcement of the arbitral award would be contrary to the public policy of that country. Here I would stop only for a moment, because what we need to focus, and especially if we pay attention, and my focus point today is how to make payments, how to comply with an arbitral award, considering a sanctioned award debtor or a sanctioned award creditor perspective and situation, is to understand that actually the point B is the enforcement itself, the recognition itself would affect the potentially violating the sanction regime. So the result of the recognition and the enforcement would breach the sanction regime of the forum. We have, of course, two perspectives here. The sanctioned country perspective saying that giving effect to a sanction regime would cause a public policy matter, and from a country imposing the sanction is not giving effect to a sanction would be rather the relevant one. Sorry, just going back to my head. Just yes. So saying that sanctions are indeed form part of public policy, the overriding mandatory provisions. Of course, this is not as easy to say. There are some issues out there, and Sebastiano also mentioned many aspects, that many issues are not really clear or settled, rather saying that. There are views that saying that, more permissive views saying that public policy doesn't compromise actually all overriding mandatory provisions, and it means in practice that actually not complying with an overriding mandatory rule doesn't necessarily mean violation of the public policy. So since public policy is more a hardcore of a social system. But contrary to this, I will follow the other line of argumentation that sanctions are part of public policy because they have all of the necessary requisites that they need as to be qualified as overriding mandatory provision. UN sanctions, this is not really a question by that time, that they amount to a breach of public policy under the New York Convention. So it was confirmed that they are, from the New York Convention perspective, they are part of transnational public policy. In this sense, they are definitely relevant and should be taken into consideration, of course, by arbitral tribunals also, and will be an issue at the place of enforcement in front of the regular court. The question is how we see, if we can say that there are unilateral sanctions adopted by for example, the European Union. EU sanctions constitute EU public policy. This was already envisaged in an ECO-Swiss case, actually, that violation of mandatory rules of the EU law amounts to a violation of public policy, and this is applicable in terms of recognition and enforcement of arbitral awards. On a practical level, this would, of course, propose that arbitral tribunals who face this situation are more rather say encouraged to take EU sanctions into account if the parties have assets in the EU. We were talking, I know, of many other at least as important aspects of that, but considering my topic, recognition and enforcement, of course, that's why I say that they have assets, to pay some attention to this. If there are no available assets in the EU, ignoring EU sanctions when arbitral tribunal outside the EU will not likely have any further consequences. There are some debate around that, of course, because sometimes we need to take into consideration not only need to take into consideration public policy of countries other than the forum actually is concerned. So this is, I can't say a statement there. We also need to think about, of course, public policy of other countries, not only of the forum country, but the likely interpretation will be the one that I first mentioned. Here I would stop only for a moment from a practical point of view. I was saying that the arbitral tribunal should think about enforceability of the award. In my opinion, the most important obligation of the arbitral tribunal is to render a legally correct arbitral award. Actually, this is the duty of the I think the main duty of the arbitrators. Although, of course, and even there are many arbitration rules pointing out this, the arbitral tribunals should or shall make every effort, to make sure that the arbitral award will be enforceable. That is not easy in practice because sometimes, of course, the enforceability is not predictable, and the parties may have assets in different jurisdictions, and these different jurisdictions may, of course, have different implications in terms of sanctions or any other type of issue that can be relevant from a, let's say, public policy perspective and public policy exception perspective. So, but definitely there is, how to say, there is indeed an expectation out there from the side of the parties that arbitrators pay attention to these, take into consideration, and if there is only one place of assets and they know about that, to think about that while they are rendering the award. Saying that, as I mentioned, I would, if I may say, rather advocate for the opinion that primarily they need to render a correct award at the place of arbitration in this sense. But of course, it's always good to think forward. And other issue actually very practical, saying that, well, this is not a public policy matter at all. Let's do it like deal with this problem of enforcement, and that is not possible, for example, to transfer funds because we have regulations on that. Say that rather put on hold the enforcement procedure itself, saying that this is not a public policy matter. Sanctions would not render an arbitral award unenforceable, even if at the place of arbitration it could be an issue, but saying that it's possible to confirm the award, but the payment based on the award should be distinguished from this category, saying that it is something that we need to cope on the enforcement level, we need to put on hold, we need to wait until the moment the sanctions are lifted. Once the sanctions are lifted, we will proceed, of course, with the enforcement procedure. We don't have res judicata issue in this sense, since we already in the procedure and there is no final decision saying that there is no possibility to enforce the award. And of course, we also don't have issue with the time of limitations. This idea, let's say like that, and I'm sure that many of members of the audience heard about it. There was in a very important Ukrainian case, there was an issue around that to say there is not a public policy matter, but it's rather an issue that can be dealt with on the enforcement level. But of course, the situation is very different now compared to that of previously. But there was also US case law saying that we need to distinguish confirmation from payment. And if you don't need to execute any payment when you need to comply with an award, then we maybe don't even have an issue of public policy. If the matter is public policy, would mean that the enforcement itself would trigger the public policy problem. Since I need to transfer funds, I need to receive money, I need to transfer money. And this is the element that I would violate, let's say, EU sanction regime. So this is also an interpretation. I wouldn't say that nowadays this is the one to put on hold the enforcement procedure would be the one that would stand for, but at least an interpretation. Now we can turn to the next issue that I was saying that, well, making payments, right? So we have an award, we have a sanctioned award debtor, maybe a sanctioned award creditor, different perspective and difficulties, and how to overcome this. Niamh already mentioned very important actual provision for the respective EU regulation dealing with the licensing, but I would just go a step back. So the award debtor is precluded. This is how we will face the problem. The award debtor is precluded from making a payment to a sanctioned award creditor. We can imagine a situation like that, or the sanctioned award debtor is precluded from paying with frozen funds. So yes, I would not really focus on that, but we of course imagine a situation when there is an award in the favor of a person who is actually subject to an asset freeze under EU regulation. We can assume that there is no licensing ground. It's not possible because by that time we know that it's a hypothetical, but we know that the license can be granted in favor of not a party who is a sanctioned party. So no licensing ground is allowed, and the payment to be made, then the party, we can say what would happen with the other party in this case. So we can say that maybe this party shouldn't be subject to any further liability for the non-payment, since the sanction is applicable. So when the sanction continues to apply, this is the situation. There are other opinions or suggestions out there to put the money into escrow to make sure that no running of late interest payment situation we face. Put the money into escrow. It means that you comply with the award, and then this is also a method of performing and complying with the provisions of the award, but of course not to the sanctioned award creditor itself directly. The other perspective is the sanctioned award debtor is precluded from paying with the frozen funds. Actually, this is what we briefly already touched upon a little bit. It means that, yes, even if payment is prohibited, because in many situations, we already talked about but what means that the assets are frozen. What means that assets, economic resources, owned, held, controlled, it was already mentioned, by persons, designated persons, entities are blocked. It means that, of course, it's not available for them, neither directly, neither indirectly. So we need a license. And how to ensure a license? There are many sanction regimes make the opportunity for the parties to apply for an authorization, a license. The situation, of course, is that how to apply. It sounds very easy. How to apply and who should apply, where to apply. In this sense, of course, the place where to apply would be the place of enforcement, when we have the assets there. So we need to send an application to the authority who has a competence at that place. The party who would like to enforce the award should take steps to do that. The question is when to apply. Of course, the earlier the better. If you would like to ensure some protective or preliminary measures in the enforcement procedure, they will ask you if you already have the license or not. If you need an attachment, the situation is again the same. So there is a kind of not only opinion that proposals from practitioners that it's better to try to secure a license. It sounds very easy, but it's difficult to secure a license even before the actual enforcement procedure is initiated. Here is the provision as mentioned by Niamh, very controversial and interesting, and I thought that we will elaborate on that this is something misunderstanding here. There was no intention to make distinction between the two regimes, but I understand that this is how it is, that in terms of arbitral decisions, the funds of economic resources subject to arbitral decisions rendered only prior to becoming listed. So this is something that we need to know and need to think about. And of course, there are other criteria. I put it on my slide. If somebody is interested in it, in order to obtain a license, what you need to take into consideration. What I would like to mention, it's very important. The banks, the agreement of the banks, because I was saying you have the authorization, but the thing is that the banks are also a very important, actually practical factor in this whole situation. I am saying that many banks who are actually involved in an international system, and they need to comply with very strict regulatory measures, and sometimes they are contradictory. So they are rather implement different kind of policies, saying that it's better to stay on the safe side, and they very cautiously move with any transaction involving sanctions. And even if it happens, this will take some special amount of time. So we also need to think about their perspectives, that they, of course, need to mitigate a risk arising from different jurisdictions and laws applicable to their operations, actually. Going back to my of course, main topic, why I was talking about this licensing issue, release of frozen assets in correlation of public policy. Because, well, once you have the authorization and it's possible to proceed with the payment, then we can't claim anymore, of course, that is a public policy issue. But I mean under that, enforcing an award against a released asset cannot be deemed to be in conflict with public policy in the place of enforcement, even, it's very important, even if the award debtor is still a listed entity or individual, since we have the license. So this is how it correlates to public policy. I'm seeing that I'm running out of time, just few sentences, and I'm happy to share the PowerPoint presentation, of course, with the participants. The exclusive jurisdiction, because we were talking about this perspective, what's the Russian perspective, taking consideration the reality now. Of course, there's an exclusive jurisdiction. There was a huge debate around that and discussion and interpretation. And this is not a new provision. This is back to 2020. So when saying, oh, there is exclusive jurisdiction, it was already over there. When sanctions persons are concerned, when there's a matter when sanctions are concerned, and there is an issue of access to justice on the part of the Russian party, then they can claim that they would like to go to a Russian court and request an anti-suit injunction in Russia, and they would like to terminate the, let's say, the pending arbitration procedure. Of course, needless to mention that a foreign award ignoring the sanctioned party to terminate the proceeding, to transfer, let's say, the case to a Russian court will be so in the case that you don't comply with this in Russia, it will be unenforceable, the arbitral award not complying, the process not complying with this, not complying with the anti-suit injunction in terms of the party, obliging the party to quiet the case and go to the Russian court. The practical implication and how to say the danger in it comes up, in my opinion, of course, only if you have assets in Russia, in the sense that you would like to enforce an arbitral award there, but it's, of course, in general, it's difficult to enforce an arbitral award in Russia, and it was studies proving this in terms of numbers, but on a theoretical and legal level, so this exclusive jurisdiction can cause a problem for us. And indeed, if there was an anti-suit injunction, you don't comply with it, fines are imposed on this party, and let's assume they have assets in Russia, then these assets can be used to recover the fines imposed for the not obeying party for not complying with the anti-suit injunction. Again, what we can say that the practical consequences, there's no significant risk in it unless we have these issues. There is a new legislation. Actually, this is something that will be a new legislation. Last year I had a conference and I was saying the same. This is still not enacted. This is again exclusive jurisdiction matter, but a more, we can say the scope is even broader, but the matter, then the issue is the same. If there is a sanction, then the Russian parties, we can say that they can able to even walk away, yes, things like that. And of course, this may improve the level of interest on the Russian parties in foreign legal disputes. But again, this is a case and relevant for us if we have assets there, and we need to take into consideration how the Russian jurisdiction is operating. As we could see, there are many issues in terms of post-award implications of the sanctions, and very practical, and of course many theoretical aspects also. And we will see how the licensing actually in long term will play out, and how the sanctions will come up in the idea of transnational public policy in long term. Thank you very much for your attention.
Thank you so much, Manuela, for such interesting insights into interplay between arbitration and sanctions. It was super interesting. I now would like to complete the second part of this webinar, which related to arbitration, and we would finally switch to the final, but no less important, and even maybe one of the most heated issues for Ukraine right now, the part of the webinar which relates to reconstruction of Ukraine and interrelationship of this reconstruction with sanctions. And I will now invite our next speaker, Professor Marcin Menkes, who is of Counsel at Kuriches, professor at Warsaw School of Economics, and currently visiting professor at the Free University of Brussels. He was appointed visiting fellowships at world's leading universities in France, Italy, in the United Kingdom, and the United States. His legal practice focuses on international dispute settlement. His academic work focuses on economic sanctions, sovereign immunities, and economic governance. Notably, Professor Menkes has published 4 books, more than 100 scientific articles, and more than 1,000 blog posts, newspaper articles, and other interesting pieces of information, which I totally love to read, to be honest. He regularly appears at international conferences and in public media. At this webinar, Marcin will address international economic sanctions for the reconstruction of Ukraine. Marcin, thank you so much for joining us today and for waiting for your turn to take the floor. The floor is yours.
So many thanks, Vicky, to you and to the Ukrainian Bar Association for organizing the timely event. It's already over 2 hours, so I'll try not to abuse anyone's patience at this point.
We have interesting topics here.
I'll try to build up on what has been said before, mostly on what Alexandra touched upon, partly using what Manuela mentioned in terms of using and attaching certain assets, and try to highlight key elements for harnessing the power, the strength of the international economic sanctions for the reconstruction of Ukraine. And I wanted to do it in 3 steps. To begin with a, let's say, helicopter view of what are sanctions, to recall what's the purpose or goal of sanctions, which will allow us to switch the perspective on economic sanctions from negative measures to positive measures, and based on that, to try to harness, to use this power, perceiving both challenges ahead and the opportunities to use those assets. So point 1, purpose of sanctions, the notorious problems of sanctions definition. It is clear that sanctions, legitimate sanctions, include measures that are intended to stop unlawful behavior, here unlawful aggression. It is not non-controversial that they can be used to compel change of policy of the addressee of the sanctions. Somewhat more tricky is whether sanctions can be used for providing compensations or damages to the victims of policies or behavior we're trying to sanction. And obviously that's what I'm mostly interested in today, which kind of reverse my priorities or order of looking at sanctions. So far, we've been discussing mostly negative sanctions. I think that is the restrictive measures. But if we look more systematically at sanctions, we can distinguish positive and negative sanctions. And positive would be measures that are intended to enhance, enforce, strengthen certain desired policies. And if we consider these as examples of sanctions, then we would speak of positive sanctions with regard to Russian-Ukrainian war, whereas the positive sanctions would be applied with regard to Ukraine. So granting it preferential trade tariffs, subsidies, financial assistance, but also referring to what has been said today, important for business, preferential taxation for foreign investments, or provision of guarantees for reconstruction. And to some extent, we this way try to reroute certain investment flows from going so far before the war towards Russia and to shift them towards Ukraine. Then we have, let's say, gray zone. Formally, we would say these are positive sanctions, meaning there are, my colleagues before mentioned, number of negative sanctions imposed already in Russia. And here the trick or the play is to create positive enforcement, to withdraw those measures in exchange first to have unlawful operation and then gradually contribute towards restoration of economic activity. Obviously, the last part is the long-term goal. But legally most tricky are the negative sanctions, and whether we can transform the measures mentioned so far, so notably assets seizure, freeze seizure, to use those funds for the reconstruction. And here we see a number of interesting developments in the recent months, both with regard to private and public actors. With regard to private asset and private actors, I would just mention 3 examples. In May 2022, Canada adopted as a part of their Budget Implementation Act, new provisions that allow for seizure and forfeiture of property of Russian oligarchs, and then using those assets for the purposes of assisting Ukraine. Something similar law has been adopted in the US in December last year, by virtue of White House Graham amendment. Same objective or a goal that is tapping private assets for the benefit of Ukrainian entities. And earlier this year in February, the Swedish presidency of the Council of the European Union announced that we would establish a working group which would be looking for legal possibilities to use frozen Russian assets for the reconstruction. And this is merely normative framework, but it's already happening, taking place. So in terms of the mentioned Canadian initiative, we've seen in December last year that the Canadians used this new tool for the first time, seizing some $26 million from Roman Abramovich Granite Capital Holdings Limited. And then in February this year, that is very swiftly, right after the Graham White House amendment, the U.S. Attorney General Merrick Garland announced that the U.S. is seizing some $5.5 million from of Mallet-Prevost's assets. And there are further initiatives, including the U.S. Task for Capital Capture, currently seeking some seizure of some $75 million. So that's part of the story here. We've heard notably Alexandra mentioning the constitutional and property law restrictions, the foreign investment restrictions, human rights restrictions, and there is one set of legal problems. But today I wanted to focus on the second class or group of problems which arise while trying to turn negative sanctions into positive sanctions with regard to public assets. You may have picked up that Alexandra mentioned a proposed bill with legislative work pending before the UK Parliament on the seizure of Russian state assets and support for Ukraine bill. It has been tabled in February this year. It has triple goals. So basically, the bill means that if it is adopted, it provides instructions for the government to lay substantive law. So far, it's more of a legislative framework, and I would say wishful thinking, than actual substantive provisions. We don't know how they're going to flesh out those ideas. The authors of the draft suggest that the bill should allow to seize those assets to halt Russian assault on Ukraine's territorial integrity, sovereignty, and independence, to hold Russia accountable. This obviously includes financial accountability, and then use those financial assets to support Ukraine. What is interesting is that aside from listed individuals or sanctioned individuals, the bill would also cover the assets of Russian Central Bank, the National Wealth Fund, which is one of the larger sovereign funds of that kind in the world, the assets of Russian Ministry of Finance and their subsidiaries, instrumentalities. Now, what is already confusing is the declared purposes for which those assets can be used. The list, by the way, starts with the payment of court fees and expenses incurred by the trustee of the Russian assets. I would say that's pretty much in line with domestic procedural rules in many states. But then we have a huge variety of goals, from supporting Ukrainian refugees in UK towards funding ongoing reconstruction needs of Ukraine, towards financial support of its military efforts, to the establishment of some post-war dispute settlement mechanism that will hold Russian actors liable, accountable for what's going on. Finally, enforcement of judgments and awards, the matter touched upon by Manuela just seconds ago. Why is it challenging, and what opportunities do I see to make it happen? Challenging. Let me just flag two elements. First of all, we probably all recall the 2012 ICJ judgment in the matter of jurisdictional immunities of states, and the matter between Germany and Italy. And at the time, the International Court of Justice, which is relatively new judgment. At the time, the court stated that even though it does not question that international crimes committed by Third Reich were unlawful, and that whatever he says afterwards doesn't undermine unlawfulness of these acts, nevertheless, he found that, well, crimes are a matter of substance, immunity is a matter of procedure. Therefore, because of sovereign immunities, he couldn't even examine the contents of the matter. Even in such a case of international crime, international crime. So that's international customary law or international case law. Secondly, and this goes particularly to the UK as one of the only 8 states which are members to the 1972 European Convention on State Immunities, which again operate on 2 levels. State sovereign immunities prevent exercising jurisdiction over third states with certain exceptions. But even with those exceptions, we have, for instance, waiver of immunity or conducting actions which cannot be considered as exercise of acta iure imperii, as exercise of public powers, possibly abuse of powers. But even having those exceptions, we have Article 31, which stipulates that the Immunities Convention does not influence the enjoyment of sovereign immunities with regard to the actions of the military in another state. And this is, let's say, the relatively easier level because it only, so far we've been talking only about the jurisdictional immunities. And then this further, which effectively we're considering with regard to central bank assets, which are most interesting here, is the immunity from enforcement. Here, whereas Alexandra already mentioned the evidentiary threshold and procedural safeguards to seize assets in certain countries are relatively low. The longer we hold assets, or the more restrictive nature of such measures, the higher threshold of judicial control. So perhaps seizure does not require preemptive control, but when we actually have frozen certain assets, there's certainly the interested party have a recourse to the court. Spoiler alert, I think that the UK parliamentarians so far are trying to avoid judicial control. For me, it is a mistake. This is precisely what they should do. That is, give opportunity for law to change to current circumstances, rather than try some artificial tricks pretending it's something else than it really is. Another challenge, or at least issue to take into account, though this will differ depending on jurisdiction, is particularly those assets of central banks. So under customary international law, we usually believe that state property enjoys immunity from execution, with the exception of assets that are intended and used for commercial purposes. Now, thinking about the assets of National Wealth Fund or central bank, the question is that a commercial asset, financial assets held on the bank account? Does the mere legal status of the account holder, that is central bank, mean these are sovereign assets? Or should we rather analyze perceive those assets, taking into account the purpose for which those funds are being used? And here we have, let's say, 3 possible answers. Under the UN Convention on immunity from jurisdiction and of states and their property, the convention stipulates that central banks' assets are not covered by this commercial exception. So that would be a disappointing response. Luckily, this convention is not binding. More positive note, the European Convention on immunities does not say anything. And So we're left in the dark or in the gray zone. Can we contribute towards development of the sovereign immunities law? I believe or argue it's high time to do so. And then lastly, in the UK, they have their own domestic legislation, the State Immunity Act, which implemented the international customary law / European Convention into domestic law. And in accordance with the UK domestic legislation, State Immunity Act, the assets of the central bank should be considered as, should be covered by this commercial waiver. So this is the possible list of problems, opportunities. I would flag just 3 points. First of all, as mentioned before, the European Convention is the only binding international legal instrument that regulates sovereign immunities. What's more, there are just 8 parties to the convention, and if we look at the state parties to the convention, these are Austria, Belgium, Germany, Luxembourg, Netherlands, Switzerland, and the UK, meaning almost they're either within the EU or just out of the EU, like the UK, or like Switzerland, very close to the EU. We're operating within a very similar mindset, which means that whether UK acting unilaterally or, let's say, through subsequent agreement, unilaterally meaning subsequent practice within the understanding of Vienna Convention of law of the treaties, or agreement between just 8 states, this is a subsequent agreement. These 8 states have a surprisingly strong leverage over development, evolution of international law of immunities. And allegedly, arguably, that's the moment to use this power. Secondly, it is true that ICJ took this disappointing position on sovereign immunities in 2012. At the same time, it stressed it was due to the procedural nature of law on immunities. Hence, it is worth to remember that in accordance with intertemporal rules, whereas we assess legality of acts, of certain actions, in accordance with substantive law in force at the time of the action, the proceedings always are subject to the procedural norms in force at the time of the proceedings. So whatever ICJ said at the time, if following the hint, seizing the first opportunity, we contribute towards development of law and immunities, then this new procedural rules would apply to any such proceedings. And lastly, well, obviously we're aware what are the reasons for the sovereign immunities. We understand why states will be very careful or reticent to narrow it too quickly, why the city or London will be reluctant to play too aggressively with assets of central banks. At the same time, I think, and that's why I believe it must be submitted, the matter must be submitted to courts directly and not as a recourse for lack of judicial measure. Because in the end, we have something like systemic interpretation of law. We know what is the racial legacy of international law, which is the peaceful coexistence of states. So I can't, whereas if the UK Parliament tries to circumvent judicial immunity, saying, well, that's administrative action, I think that every judge would be reticent to acknowledge this lawful action. However, if asked directly, should that be allowed? I can't really imagine a legal system designed to protect international peace and security in a way that prevents judicial settlement of the dispute, of any dispute, with regards to a state which is violating the key pillars of the international legal system. And what Russia, as a permanent member of the Security Council, is currently doing clearly destroys, tarnishes the cornerstone of the entire UN system. So if I was to make sketch 3 takeaways of the presentation, first of all, it would be timing. I started with the issue of positive, negative sanctions and functions of sanctions. I think this should happen as quickly as possible, both for economic, political, military reasons to provide Ukraine funding for ongoing reconstruction, but also Whereas now there is no question of legality of sanctions. If we start to using those assets right now, it is a legally different situation than trying to wait until the hostilities are over and then try to look for a legal title for seizure, for future of those assets. So as soon as possible. Second, many stakeholders who are complaining about the gap between the evolution of jurisdictional immunities, the one considered by ICJ in 2012, and the immunity from execution. And we have very few rulings on the latter. So, well, that's yet another reason both for Ukraine and international community at large to give the system to a test and allow the judges, arbitrators to speak. And that brings me to the final conclusion: do not shy away from subjecting those new measures from scrutiny. I mean, in the end, well, that's how the international law develops, and if not now, then ever. The tendency for restricting sovereign immunities has been present for decades, and we hardly ever had a better opportunity or better case to do so. So. Thank you so much for today, and I hope that it's 6:30 in Kiev, so I kept it you.
Martin, thank you so much. That was very interesting and insightful. I totally enjoyed this information and analysis. That was the last topic to be discussed today's webinar, but that's not all for our audience. Stay tuned with us because we would have the video recording published of this webinar, and also most likely we would make a publication summarizing the topics which were discussed by today's speakers. So stay tuned and check also for our further events. Also, I wanted to say a huge thank you to our stellar speakers for agreeing to join us to share their knowledge, experience, and ideas with our Ukrainian and also international audience. Also wanted to say a huge thank you to the UBA Secretariat for making this webinar technically possible. And finally, I want to say a huge thank you to our audience for sharing this Friday evening with us. I hope that was interesting and insightful. So see you soon.
Many thanks. Bye, everyone.
Bye.